Order number 2, reading of the charges on the proposed removal from office by impeachment of Honorable Amos Kimwami Nyaribo, Governor of Nyamira County. The Honorable Amos Kimwami Nyaribo, the Governor of Nyamira County, please take the stand. Honorable Amos Kimwami Nyaribo, the Governor of Nyamira County, the charges against you as received from the County Assembly of Nyamira are as follows, and I quote: Ground 1, gross violation of the Constitution and other laws. The particulars of this ground are as follows. Allegation 1, gross violation of the Constitution 2010 and the County Government Act 2012 through deliberate formal engagement, endorsement and support of unlawful, illegal and unconstitutional bunge mashinani. Whereas Article 1, 10 and 73 of the Constitution 2010 enshrine the principles of sovereignty of the people, the rule of law and the responsibility of state officers, whereas Article 176(1) of the Constitution of Kenya 2010 unequivocally establishes a county assembly of each county, and Section 7B(2) and 14(1)(a) of the County Government Act 2012 govern the lawful sittings and procedure of the county assembly, whereas Section 6A(1) and the third schedule of the County Governments Act 2012 specifies the location of Nyamira County Government as Nyamira Urban Area, whereas Section 7B(2) of the County Governments Act 2012 provides that except for a sitting of a new county assembly, under subsection 1, a sitting of a county assembly may be held at any place within the county and may commence at any time as the county assembly may appoint. Whereas Section 32, subsection A of the County Governments Act 2012 requires the governor to diligently execute the functions and exercise the authority provided in the Constitution and the legislation, whereas Section 30, subsection 3C of the County Governments Act 2012 requires the governor to promote democracy, good governance, unity and cohesion within the county. 1. His Excellency Amos Kimwami Nyaribo deliberately engaged, endorsed, and supported unlawful, illegal, and unconstitutional bunge mashinani gazetted by Enoch Ogori Okero via Kenya Gazette Notice number 14229 of 2024, dated the 29th of October 2024, and the appointment of an acting clerk via Kenya Gazette Notice number 14230 of 2024, despite knowledge of the fact that the said Enoch Ogori Okero had been removed from the office of the Speaker by way of an impeachment as published in the Kenya Gazette number 14050 of 2024, dated 25th October 2024. 2. The Senate of the Republic of Kenya on 15th May 2025, while considering a progress report of the Standing Committee on Devolution and Intergovernmental Relations on the operation and leadership crisis affecting the County Assembly of Nyamira, resolved that the decision and resolutions made by the impeached Speaker and members of the County Assembly that convened outside the gazetted precincts of the County Assembly are null and void. The same was communicated to the Clerk of the County Assembly of Nyamira and copied to the Governor of Nyamira County via the letter reference SEN/RESOLS/17/2025, dated 22nd May 2025. 3. The impeachment of Enoch Ogori Okero was affirmed by the judgment of the High Court at Bomet in petition number E004 of 2025, delivered on the 4th day of June 2025. In paragraph 74 of the said judgment, it was the court's finding that the 7th respondent, Enoch Ogori Okero, the impeached speaker, ceased to hold office on the 24th of October 2024. 4. Further, in paragraph 85 of the same judgment, the court found that any actions or duties performed by the 7th respondent, Enoch Ogori Okero, the impeached speaker, were illegal, null, and void, as the 7th respondent either had the power nor the locus to do so. Whereas the governor and his accomplices maintained there were court orders stopping the county assembly from removing Enoch Okero from the office of the speaker. 5. The High Court at Bomet, by the judgment in petition number E004 of 2025, delivered on the 4th day of June 2025, settled this matter and held that there was no such order and that the county assembly was not barred from impeaching Enoch Ogori Okero from office of the speaker or exercising its constitutional mandate. The same is found in paragraph 72 of the said judgment, where the court held that, I quote, "This court's critical interpretation of order number 2 issued on 11th October 2024 by Okwani J was that she issued conservatory orders staying the suspension of the 7th respondent as speaker. This effectively meant that 7th respondent resumed his duties as speaker of the county assembly. In regards to order number 3, the judge issued conservatory orders that barred interference of the duties of the 7th respondent as speaker. Order 3, as worded above, did not mention that the county assembly of Nyamira was barred from impeaching 7th respondent or exercising its constitutional mandate. 6. His Excellency Governor Amos Kimome Nyaribo consistently and deliberately supported and engaged with gatherings of unlawful, illegal, and unconstitutional bunge mashinani, which conducted its meetings from October 31st, 2024 up to June 2025 in locations away from the lawful and official gazetted premises of county assembly and without lawful appointment. 7. Further, the governor made public pronouncements declaring Enoch Ogori Okero and Sylvanus Ndemo Nyamora as the legitimate speaker and clerk respectively, while aware that Enoch Ogori Okero was duly impeached. 8. The governor's actions to formally engage, endorse, and support unlawful, illegal, and unconstitutional bunge mashinani directly undermined the legislative representation and oversight role of the County Assembly of Nyamira as established by the Constitution of Kenya 2010 and County Governments Act 2012, thereby constituting a gross violation of the rule of law and the principle of separation of powers. Allegation 2, gross violation of the Constitution of Kenya 2010 and the County Government Act 2012 and the Public Finance Management Act 2012 by assenting to the Nyamira County Supplementary Appropriation Bill 2024 without the approval of the County Assembly of Nyamira. Whereas Article 175A of the Constitution of Kenya 2010 requires that the county government shall be based on the democratic principles and separation of powers, whereas Article 185(1) of the Constitution of Kenya 2010 states that the legislative authority of a county is vested in and exercised by its county assembly, whereas Article 224 of the Constitution of Kenya 2010 states that on the basis of the Division of Revenue Bill passed by Parliament under Article 218, each county government shall prepare and adopt its own annual budget and appropriation bill in the form and according to the procedure prescribed in an Act of Parliament, whereas Section 21, subsection 1 of the County Governments Act 2012 requires that the County Assembly shall exercise its legislative power through bills passed by the County Assembly and assented to by the Governor. Whereas Section 130 of the Public Finance Management Act 2012 provides for the procedures of processing a county budget, including transmission from the county executive to the County Assembly for consideration and approval. 1. The Governor on 26 November 2024 assented to the Nyamira County Supplementary Appropriation Bill 2024 without the approval of the County Assembly of Nyamira, in total defiance to the constitutional principle of separation of powers. 2. The Nyamira County Supplementary Appropriation Bill 2024 is not among the business transacted during the morning and afternoon sittings of the County Assembly of Nyamira on 26 November 2024. 3. The Nyamira County Supplementary Appropriation Act 2024, as assented by the Governor, significantly altered the priorities and development programs in the original approved budget. 4. This conduct constitutes a gross violation of Articles 175A, 181(1), and 224 of the Constitution of Kenya 2010, Section 130 of the Public Finance Management Act 2012, Section 21(1) of the County Governments Act 2012, and Order Number 137(1) of the County Assembly of Nyamira Standing Orders, and the due process of the law, which requires that the county budget be approved by the County Assembly. 5. The same undermined the representation and oversight role of the County Assembly. The supplementary budget was assented to, devoid of participation of the people and or their representatives. Allegation number 3. Gross violation of the Constitution of Kenya 2010 and the County Governments Act 2012 by appointing Dr. Peris Nyaboke Oroko, alias Peris Mongare, to the County Executive Committee CEC without the approval of the County Assembly. Whereas Article 179 2B of the Constitution of Kenya 2010 provides that the County Executive Committee shall consist of members appointed by the County Governor with the approval of the County Assembly from among persons who are not members of the County Assembly. Whereas Article 259 of the Constitution emphasizes the interpretation of the Constitution, which includes the respect for judicial announcements. Further, whereas Section 30D of the County Governments Act 2012 requires the Governor to appoint, with approval of the County Assembly, members of the County Executive Committee. Whereas Section 4 of the Public Appointments, County Assemblies Approval Act 2017 requires that an appointment under the Constitution or any other law for which the approval of a County Assembly is required shall not be made unless the appointment is approved by the relevant County Assembly in accordance with this Act. 1. His Excellency Amos Kimomi Nyaribo appointed Dr. Peris Nyaboke Oroko to the County Executive Committee without the approval of the County Assembly of Nyamira, in total disregard of the due process of the law. 2. In response to an inquiry by the County Assembly, the County Executive Committee member for Public Service Management maintained that the Peris Nyaboke Oroko is duly appointed. 3. Failure to submit the name of Peris Nyaboke Oroko for vetting and approval by the County Assembly of Nyamira constitutes gross violation of Articles 179 2B and 259 of the Constitution of Kenya 2010 and Section 30D of the County Government Act 2012. 4. The Governor has to date proceeded to retain Dr. Peris Nyaboke Oroko and supervised her integration into the payroll system since June 21, 2025, and authorized the payment of her salary and allowances despite clear judicial and senatorial pronouncements declaring all actions of Bunge Mashinani as illegal, null, and void. 5, the governor willfully circumvented the legitimate constitutional approval process, rendering the appointment unlawful. 6, this action presently bypassed the county assembly, constituting a gross violation of the Constitution and statutory provisions governing appointments. Allegation number 4. Gross violation of the Constitution of Kenya 2010, the Urban Areas and Cities Act 2011, and Public Appointments County Assemblies Approval Act 2017 by appointing Nyamira and Clerk municipalities board members without the approval of the County Assembly of Nyamira. Whereas Article 10 of the Constitution on national values and principles of governance requires that the observance of the rule of law, good governance, integrity, transparency, and accountability. Whereas Section 14, subsection 1 of the Urban Areas and Cities Act of 2011, as amended in 2019, requires that a board of a municipality shall consist of 9 members appointed by the county governor with approval of the county assembly. Whereas Section 4 of the Public Appointments County Assemblies Approval Act 2017 requires that an appointment under the Constitution or any other law which the approval of a county assembly is required shall not be made unless the appointment is approved by the relevant county assembly in accordance with this act. 1. His Excellency Amos Kimomi Nyaribo, by the Gazette Notice number 1965 of 2025, dated 30th February 2025, appointed members to the boards of Clerk and Nyamira municipalities without the approval of the County Assembly of Nyamira, in direct defiance of the Constitution of Kenya 2010, the Urban Areas and Cities Act 2011, as amended 2019, and the Public Appointments County Assemblies Approval Act 2017. 2. The approval of the members to the 2 board members was not among the business transacted during the morning and afternoon sittings of the County Assembly of Nyamira on 19th November 2024. 3. The governor has to date retained the said board members in defiance of clear judicial and senatorial pronouncements. 4. This constitutes a blatant disregard for the rule of law and contempt for legitimate authority. Allegation number 5. Gross violation of the Constitution of Kenya 2010 and the County Government Act 2012 by appointing the selection panel for the recruitment of the chairperson, secretary, and members of the Nyamira County Public Service Board, CPSB, without the approval of the County Assembly of Nyamira. Whereas Article 10 of the Constitution on the national values and the principles of governance requires the observance of the rule of law, good governance, integrity, transparency, and accountability. Whereas Article 73 and 74 of the Constitution 2010 outline the responsibilities of state officers and the principles of public service, demanding objectivity, impartiality, and accountability. Whereas Article 232, subsection 1 of the Constitution 2010 sets the values and principles of public service, requiring efficient use of resources, transparency, and fair competition and merit. Whereas Section 4 of the Public Appointments County Assemblies Approval Act 2017 requires that an appointment under the Constitution or any other law for which the approval of a county assembly is required shall not be made unless the appointment is approved by the relevant county assembly in accordance with this act. 1. The governor appointed a selection panel for the recruitment of the chairperson, secretary, and members of the Nyamira County Public Service Board, CPSB, without the approval of the County Assembly of Nyamira. 2. The governor willfully circumvented the legitimate constitutional approval process, rendering the appointment unlawful. 3. The selection panel proceeded to invite, shortlist, and conduct interviews for the applicants for the positions of chairperson, secretary, and members of Nyamira County Public Service Board, in total defiance of clear judicial and senatorial pronouncements. 4. These actions are contrary to the constitutional principles and undermine public service integrity. Allegation number 6. Gross violation of the Constitution of Kenya 2010, County Governments Act 2012, by failing to appoint the chairperson, secretary, and members of the Nyamira County Public Service Board. Whereas Article 235 of the Constitution of Kenya 2010 provides that a county government is responsible for A, establishing and abolishing offices in its public service, B, appointing persons to hold or act in those offices and confirming appointments, and C, exercising disciplinary control over and removing persons holding or acting in those offices. Whereas Section 58A(1) of the County Governments Act 2012 provides that whenever a vacancy arises in a county public service board, the governor shall nominate and, with approval of the county assembly, appoint members to a selection panel for the purpose of selecting suitable candidates for appointment as members of the County Public Service Board. And whereas Section 58A(7) provides that the governor shall, within 7 days of receipt of the names forwarded under subsection 6, nominate one person and at least 3, but not more than 5 others for appointment as chairperson and members of the County Public Service Board, respectively, and forward the names to the County Assembly for approval. 1. The Governor, His Excellency Amos Kimomi Nyaribo, has to date failed to nominate for vetting, approval, and appointment of the chairperson, secretary, and members of the Nyamira County Public Service, despite vacancies arising in the Nyamira County Public Service Board as from 5th of July 2025. 2. The absence of a County Public Service Board has created a lacuna in management of the human resource function of the county government of Nyamira. In the obtaining circumstances, the provisions of Article 235 of the Constitution of Kenya 2010 cannot be realized in the Nyamira County Public Service. 3. Additionally, this has eroded confidence and public trust in the leadership of Governor Amos Kimomi Nyaribo. Allegation number 7. Gross violation of the Constitution of Kenya 2010 and the County Governments Act 2012 by failing to submit annual reports and deliver an annual State of County Address to the County Assembly for 2 consecutive years. Article 183(3) of the Constitution of Kenya 2010 provides that the County Executive Committee shall provide the County Assembly with full and regular reports on matters relating to the county. And Section 32(J) and (K) of the County Government Act 2012 mandates the governor to J, I quote, under J, submit to the County Assembly an annual report on the implementation status of the county policies and plans. K, deliver annual State of the County Address containing such matters as may be specified in county legislation. 1. The governor has failed to submit annual reports and deliver annual State of the County Address to the County Assembly of Nyamira for the past 2 consecutive years, 2023-2024 and 2024-2025, as required by law. 2. This failure constitutes a gross violation of constitutional and statutory provisions, demonstrating a blatant disregard for transparency, accountability, and the oversight role of the county assembly. It further denies residents of Nyamira County an opportunity to hold their governor accountable. 3, the governor's consistent and prolonged failure to deliver the constitutionally required State of the County address demonstrates a deliberate act to evade accountability to the county assembly and the people, thereby constituting gross violation of constitutional and statutory mandates. Allegation number 8, gross violation of the Constitution of Kenya 2010 by failing to appoint and obey court orders regarding the appointment of Clerk Ogwora to the County Executive Committee. Whereas Article 159(1) of the Constitution of Kenya 2010 provides for the exercise of judicial authority, whereas Section 14(1)(a) of the Contempt of Court Act 2016 provides that contempt of court includes civil contempt, which means willful disobedience of any judgment, decree, direction, order, or other process of a court, or willful breach of an undertaking given to a court. Whereas the Employment and the Labor Relations Court at Kisumu in ELRC JR number 10 of 2021 ordered the governor to appoint and pay salaries to Mr. Clerk Ogwora. 1, His Excellency Amos Kimomi Nyaribo failed to appoint Mr. Clerk Ogwora nominee for member of the County Executive Committee, despite the fact that the nomination was cleared by law for appointment. 2, the governor's disobedience of the High Court order directing him to appoint Mr. Clerk Ogwora resulted into the loss of a discrete sum of Kenya shilling 4,417,875. 3, the actions of the governor, including delayed settlement, resulted into loss of public funds amounting to Kenya shilling 6,922,203.75, being the discreto sum plus costs, interest, and other incidentals. Ground 2, abuse of office. Whereas Article 10 of the Constitution on national values and principles of governance require the observance of the rule of law, good governance, integrity, transparency, and accountability. Whereas Articles 73, 74, and 75 of the Constitution 2010 outline the responsibilities of state officers and the principles of public service, demanding objectivity, impartiality, and accountability, among others. Whereas Article 232, 1 of the Constitution 2010 sets the values and principles of public service, requiring efficient use of resources, transparency, and fair competition and merit. Whereas Section 46 of the Anti-Corruption and Economic Crimes Act of 2003 provides that a person who uses his office to improperly confer a benefit on himself or anyone else is guilty of an offense. His Excellency Amos K. Nyaribo abused his office in the management and administration of county affairs through the following acts as particularized below. The particulars of this ground are as follows. Allegation 1, abuse of office by improper use of his authority in recruitment of staff without approved budget, the recruitment frenzy. Whereas Article 10 of the Constitution...
Clerk, just give me a minute. His Excellency, the Governor, we still have a long way to go reading your charges. In the event that you're tired, you may take a seat. We don't want you to collapse while these charges are being read. Proceed, Clerk.
Thank you.
Allegation 1, abuse of office by improper use of his authority in recruitment of staff without approved budget, the recruitment frenzy. Whereas Article 10 of the Constitution on national values and principles of governance requires the observance of the rule of law, good governance, integrity, transparency, and accountability. Whereas Article 73, 74, and 75 of the Constitution 2010 outline the responsibilities of state officers and the principles of public service, demanding objectivity, impartiality, and accountability. Whereas Article 201A, D, and E of the Constitution of Kenya 2010 states as follows. A, there shall be openness and accountability, including public participation in financial matters. D, public money shall be used in a prudent and responsible way. E, financial management shall be responsible and fiscal reporting shall be clear. Whereas Article 232(1) of the Constitution 2010 sets the values and principles of public service, requiring efficient use of resources, transparency and fair competition and merit. And whereas Section 107(2)(c) of the Public Finance Management Act 2012, PFM Act, require that the county government's expenditure on wages and benefits for its public officers shall not exceed a percentage of the county government's total revenue as prescribed by the county executive member for finance in regulations and approved by the county assembly. Whereas Section 8(1)(c) of the County Governments Act 2012, which provides for the role of the county assembly, including approve the budget and expenditure of the county government in accordance with Article 207 of the Constitution and the legislation contemplated in Article 2202 of the Constitution, guided by Articles 201 and 203 of the Constitution. 1. His Excellency Amos Kimwami Nyaribo presided over and influenced the approval of recruitment of staff without an approved budget as demonstrated in County Executive Minutes MIN number 04/02/2021 of 26 February 2021 in his response to an inquiry from the Controller of Budget. This recruitment was approved by the County Executive with full knowledge that there was no budgetary provision. In the said response to issue number 4 in the question, the Governor alleged that in lieu of the budget, the recruitment was based on the savings made from various separations, which included but not limited to recruitment and resignations. 2. Despite a resolution of a county assembly to freeze new employments on account of lack of budgetary provision for any recruitment dated 1st July 2021, which freezing was never vacated by a resolution of the county assembly. 3. Further, in spite of an advisory from the Secretary of the County Public Service Board dated 29 July 2021 to the County Executive to put the impurged recruitment in abeyance, considering that there is no budgetary provision for any new recruitment. 4. His Excellency Amos Kimomi Nyaribo has to date proceeded with a recruitment frenzy that has ballooned the county wage bill, making it unsustainable, irresponsible, and imprudent, contrary to the provisions of the Public Finance Management Act 2012. 5. The Governor's influence over the recruitment of hundreds of staff without budget, in defiance of EACC advisory and county assembly resolutions for political expediency and personal gain, constitutes a clear abuse of office aimed at fiscal plunder and violation of constitutional values and principles of governance. 6. Since the year 2021, when His Excellency Amos K. Nyaribo assumed office as governor, he has influenced the recruitment of staff without budgetary provision and approval of the County Assembly of Nyamira, and particularly A. In February to April 2021, there was a recruitment of 49 officers. B, the recruitment of Deputy County Secretary, County Attorney, support staff, ward and county and sub-county administrators. C, on March 9, 2023, the County Public Service Board advertised for 358 vacancies. Despite the lack of approved budget for recruitment, a recruitment freeze by the County Assembly, and disregard for EACC advisories. The recruitment, projected to add Kenyan shilling 325 million annually, proceeded without any budgetary allocation or approval. D, outstanding arrears to the tune of Kenyan shillings 60 million arising from unpaid salaries to healthcare workers for a period of 7 months. Allegation number 2, abuse of office by influencing the appointment of Godfrey Kiriago and Elmelda Nyaberi as Director of County Human Resource Management and Assistant Director Human Resource Management, Payroll Management, respectively. Whereas Article 179 of the Constitution designates the county governor as the chief executive of the county, whereas Article 232 1G of the Constitution of Kenya 2010 mandates fair competition and merit as the basis for appointments and right to equality and freedom from discrimination, whereas Articles 75, 76, and 77 of the Constitution govern the conduct and financial probity of state officers, whereas Section 30 of the County Government Act 2012 provides for the functions of the governor, whereas Section 45 of the Anti-Corruption and Economic Crimes Act of 2003 provides for protection of public property and revenue, whereas Section 46 of the Anti-Corruption and Economic Crimes Act of 2003 provides that a person who uses his office to improperly confer a benefit on himself or anyone else is guilty of an offense. 1. In a letter dated 18th January 2021, the County Secretary communicated the decision of the County Executive, an organ presided over by His Excellency Amos Kimomi Nyaribo, to the County Public Service Board, seeking the secondment of 2 cherry-picked officers, Godfrey Kiriago Nyangao and Elmelda Nyaberi, to the positions of Director Human Resource and Payroll Management, respectively. In response, the chairperson of the County Public Service Board wrote back to the County Secretary demanding that the said offices ought to be vacant and that the process must follow the laid down procedures and legal provisions. 2, the governor influenced the transfer of substantive office holders to create room for the cherry-picked officers and caused irregular integration into the county payroll. 3, by initiating the non-competitive appointment and retention of the cherry-picked officers, the governor violated the principle of meritocracy and demonstrated a profound abuse of his office, leading to a direct and quantifiable loss of public funds, since the 2 officers were hitherto substantively occupied. 4, the governor further influenced the appointment of Godfrey Kiriago to the position of Deputy County Secretary and influenced the renewal of Mrs. Elmelda Nyaberi's contract post her retirement date. Allegation number 3, abuse of office through personal enrichment from receipt of irregular salary arrears of Kenya shilling 5,649,706. Whereas Article 201A, D, and E of the Constitution of Kenya state as follows. B, there shall be openness and accountability, including public participation in financial matters. F, public money shall be used in a prudent and responsible way. G, financial management shall be responsible and fiscal reporting shall be clear. Whereas Article 234A of the Constitution of Kenya 2010 mandates the Salaries and Remuneration Commission (SRC) to set and regularly review the remuneration and benefits of all state officers. Whereas Section 97 of the Public Finance Management Act 2012, PFM Act, requires public funds to be used in accordance with the law and for the purpose of which they were appropriated. Whereas Section 46 of the Anti-Corruption and Economic Crimes Act of 2003 provides that a person who uses his office to improperly confer a benefit on himself or anyone else is guilty of an offense. 1. In September 2021, through the facilitation of the two cherry-picked officers, Mr. Godfrey Kiriago, Director Human Resource, and Elmelda Nyaberi, Payroll Manager, the Governor conferred upon himself an irregular salary payment christened as arrears amounting to Kenya shilling 5,649,706. It is apparent that there was no outstanding arrears due to the governor since his assumption to office, and neither was he owed any arrears as deputy governor. 2. The governor's self-authorized receipt of Kenya shilling 5,649,706 in salary arrears outside the Salaries and Remuneration Commission guidelines is a clear act of personal enrichment, abuse of office, and a direct violation of PFM Act. 3. The governor has publicly confessed that he received the above irregular payment. The people of Nyamira lost services and development programs to the tune of Kenya shillings 5.6 million on account of his abuse of office and or his actions. Number 4, the governor has formed a habit of conferring upon himself irregular benefits going by other incidences. For instance, in the year 2019, the governor caused to be paid a retrospective compensation of Kenya shilling 13 million in allowances for housing, bracket, a benefit, not an allowance, and made a double medical claim in form of ex gratia, despite full settlement of his medical bills by the defunct NHIF, all outside of SRC guidelines, which clearly demonstrate a pattern of personal enrichment, abuse of office, and direct violation of PFM Act. 5. This direct financial benefit to the governor constitutes a direct loss of public funds and demonstrates a clear case of personal enrichment through corrupt practices and abuse of office. Allegation number 4, abuse of office through systemic payroll fraud and syndicate, the Kenya shilling 32 million payroll haste. 1. Besides an irregular receipt of Kenya shilling 5,649,706 has already established, in particular allegation 2.3, the governor presided over a well-orchestrated syndicate of payroll fraud, which led to massive loss of public funds through huge, irregular, and unexplained salaries and specified and special allowances paid to Mrs. Rose Bosibori Guto, an ECD teacher, bracket Kenya shillings 25,018,852. Ms. Gladys Mora Nyambane, an ECDE teacher, bracket Kenya shilling 1,100,467. And Mr. Isaac Kerongo Bonchiri, an ECD teacher, Kenya shilling 700,836. 2. While under oath, during his appearance before the Senate's Public Accounts Committee, the governor admitted to have received the illegal benefit. Allegation number 5, abuse of office by influencing dual appointments outside the lawful establishment. Whereas Article 235 of the Constitution of Kenya 2010 states that a county government is responsible within a framework of uniform norms and standards prescribed by an Act of Parliament for A, establishing and abolishing officers in its public service, B, appointing persons to hold or act in those offices and confirming appointments, and C, exercising disciplinary control over and removing persons holding or acting in those offices. Whereas Section 51 of the County Governments Act 2012 provides that there shall be established at the level of each sub-county the office of sub-county administrator, and whereas Section 51(1) of the County Governments Act 2012 provides that there is established for each ward in a county the office of the ward administrator. Further, whereas these offices were already substantively filled in the year 2014, upon assumption of office in 2021, the Governor, Honorable Amos K. Nyaribo, aware that these offices were substantively filled, deliberately allowed the recruitment of sub-county and ward administrators to fill the artificial vacancies, leading to double appointments and hence double payment of salaries, depriving the county of development funds. Whereas Section 10(5) of the Employment Act 2007 provides for the procedure of change of contract terms for an employee, the Governor, through letter reference NCG/TRNSF/TR/VOL/3/283 dated 27th June 2024, redeployed 10 officers, ward and sub-county administrators, to positions in which they had no requisite competencies, so as to create room for the dual appointments. Allegation number 6, abuse of office through usurpation of powers of the Auditor General and the County Public Service Board, and violation of due process through illegal payroll, audit and demotions. Whereas Article 47 of the Constitution and the Fair Administrative Action Act 2015 enshrine the right to fair administrative action and due process, whereas Article 229 4A(4) provides that within 6 months after the end of each financial year, the Auditor General shall audit and report in respect of that financial year the accounts of the national and county governments, whereas Section 59A of the County Governments Act 2012 provides that the county public service shall A, be independent and shall not be subject to the direction or control of any other person or authority, and whereas Section 59F and Section 61G of the County Governments Act 2012 vest the power to exercise the disciplinary control over and to remove persons holding in the county public service squarely in the County Public Service Board, whereas Section 35 of the Audit Act 2015 provides for the procedure and manner of auditing public entities. 1. In September 2021, the Governor purported to demote more than 100 staff, which action was reversed by the Employment and Labor Relations Court sitting in Kisumu. 2. Further, in May/June 2024, he demoted another 254 staff on the basis of a payroll audit report without the process, usurping the function that falls squarely under the purview of the County Public Service Board. 3. The Governor appointed a payroll audit team without due regard to Section 35 of the Audit Act, approval by the County Assembly or the Auditor General, contrary to legal requirement. 4. Human resource payroll relates to use public funds and can only be audited as envisaged by Article 229 of the Constitution. 5. The Auditor General is the only constitutionally mandated body to audit all state organs, including county governments, and it has not delegated any of her mandates to any institution to carry Nyamira county payroll audit. 6. The action of the governor to carry county payroll audit without proper authorization or delegation is a straight usurpation of the constitutional mandate of the Auditor General, and therefore in violation of Article 229 of the Constitution of Kenya 2010. 7. Article 226(3) of the Constitution states that the accounts of all governments and state organs shall be audited by the Auditor General. The action of the governor to carry out county payroll audit without proper authorization of the Office of the Auditor General is in contravention of the Constitution. 8. Article 229(1) of the Constitution creates the independent office of the Auditor General, and Article 229(4) of the Constitution cuts what the auditor ought to undertake. The action of the governor to carry county payroll audit without proper authorization of the Office of the Auditor General and without the knowledge of the office undermines the independence of a constitutional office and is in contravention of the Constitution. 9. Article 229(5) of the Constitution states that the Auditor General has the liberty to audit and report on the accounts of any entity that is funded from public funds. Section 34 of the Public Audit Act 2015 provides for periodic audits to be undertaken by the Auditor General at his or her own initiative or upon request by an entity. The Auditor General has audited Nyamira County. There are audit reports, and there is no explanation whether the county government found existing audit report inadequate. The governor have not requested the Auditor General to carry out any audit. The governor have not requested for the County Assembly of Nyamira to sanction the Auditor General to undertake any audit. 10. Section 23 of the Public Audit Act 2015 provides for outsourcing of audit services, while Section 24 of the Public Audit Act 2015 provides for engagement of services of technical experts or consultants and professionals in fulfillment of Article 229(6) of the Constitution, which states the principal purpose of the audit is to confirm whether or not public money has been applied lawfully and in an effective way. The Auditor General did not establish the firm that did the county payroll audit. 11. An audit is a process that follows cardinal guidelines which the purported auditors of the county executive payroll did not follow before coming up with a purported payroll audit report. Section 31 of the Public Audit Act 2015 provides how the process of the audit shall be undertaken. 12. Section 36 of the Public Audit Act 2015 provides that the audit report is submitted to Parliament or County Assembly for tabling and debate. How the county payroll audit report, which was not done by or authorized by Auditor General, will be placed to Parliament or the County Assembly for debate and consideration has not explained. 13. Section 37 of the Public Audit Act 2015 provides for the forensic audits upon request by Parliament or county assemblies to establish fraud, corruption, or financial improprieties in state organs and public entities. The audit report is then placed to Parliament or the County Assembly for debate and consideration where appropriate resolutions and actions to be taken emanate. 14. The Governor therefore usurped the constitutional mandate of the Auditor General, which he arrogated himself to initiate payroll audit without authorization. 15. The County Public Service Board, in their submissions in a county appeals matter before the Public Service Commission through the respondents' reply to appeal in paragraphs 12, 13, and 20 affirmed that the governor singularly commissioned the payroll audit, including appointment of an ad hoc committee that will digest the findings of the audit. 16, the County Public Service Board, CPSB, in a communication dated 15 January 2025, reversed the governor's purported demotions, explicitly implying that the demotions were processed without the board's involvement or approval, confirming the usurpation of the board's mandate. 17, the County Executive Committee, sitting in September 2025, resolved that it was aggrieved by the CPSB's reversal and will be appealing against this decision, fully aware that it has no provision for appealing. An advisory from the county attorney affirmed this is an advisory to the Chief Officer, Public Service Management. This further demonstrates a governor that is hell-bent in usurping the role of the CPSB. 18, the governor's actions bypassed the established legal framework for personnel management, denying the affected staff due process and leading to demoralization and disruption of service delivery. 19, the governor's decision to personally initiate and execute disciplinary action, demotions, based on an irregular audit without reference to constitutionally mandated CPSB or following due process is a clear and unconstitutional usurpation of power and violation of staff members' fundamental rights. 20, the governor's intention to appeal the decision of the CPSB was in any case an act in futility, as the decisions of the County Public Service Board are deemed to be made for and on behalf of the county government. 21, additionally, the County Assembly, while considering a report of the Sectoral Committee on Public Service Management on staff progression, passed resolutions that included, among others, 1, the reinstatement of demoted officers to their rightful job groups and payment of their full emoluments. 2, the censure of the Chief Officer, Public Service Management, Mrs. Rael Omanyi, and the further resolution to have her step aside for contempt of the County Assembly and its committees. 22, the governor has to date failed to enforce resolution number 2 above and equally failed to implement the resolutions of the County Assembly in this report. Allegation number 7, abuse of office by purporting to suspend the Secretary to County Public Service Board. Whereas Section 58(5)(b) of the County Governments Act 2012, as read together with Article 2511 of the Constitution of Kenya 2010, provides that the members of the board may only be removed from office by a vote not less than 75% of all the members of the County Assembly. 1, the above article and or section do not anticipate or confer power upon the governor to cause such an action as suspension of a secretary to the County Public Service Board. 2, His Excellency Amos Kimwomi Nyaribo acted ultra-vires by purporting to suspend the secretary to the County Public Service Board by the letter reference NCG/GVN/legal/VOL .1 dated 2nd May 2023 beyond his powers as provided for in Section 31 of the County Governments Act 2012.
You may proceed, Clerk.
Honorable Amos Kimwomi Nyaribo, how do you plead to the 2 grounds, guilty or not